Hi, good afternoon. Hope all of you are hearing me clearly. My name is Sarah. This may be the first time some of you may be seeing me, but probably you have also seen me in preview classes, the information session that we did, right? But if this is your first time, then my name is Sarah, and I do teach contract law, EU law, evidence, and intellectual property. For first year, I do teach contract law only. So we will be seeing each other very frequently after this, all the way up to next year around April until your revision ends for contract law. We'll be meeting each other very soon. Together with me, my colleagues will be teaching you contract law as well. So apart from me, you will also see Miss Vigna frequently, right? There's also another Mr. Sarah, right? He shares my name. He also does teach contract law. You will be also seeing him. And all three of us will be taking care of your contract law lesson, right? We'll be guiding you all the way towards revision, right? So this is the first class for contract law, the very first class for contract law. And before I proceed with contract law, because this is the usual stuff that we have to do in every first lesson, we cannot proceed with the law directly. We have to say to students a few things, right? Because you have to know what are the books that you're supposed to study, right? How do this contract law works, the exam format, and other things, right? These are the things we have not really looked at in your preview. While we were looking at the preview, we did not really look at this in detail. So I'm going to tell you a few things about contract law first before I move on into the chapter for today, which is chapter 1, intention to create legal relationship. But before that, I'm so sorry that the yesterday's class had to be cancelled. But we will postpone the class. We have postponed the class to next week, Saturday, from 9:30 a.m. to 12:30 a.m. So by next week, Saturday, we'll be done with this whole session. Tomorrow, the class will go on from 9:30 to 1:30 as usual, right? So yesterday it was cancelled. Today, the class is going on as usual. Tomorrow, the class will go on as usual as well, 9:30 to 1:30. Then next week, we have 9:30 to 12:30. Okay, so what I want to tell you is this. Let me share the screen for a while. Oops. Just give me a second. Just give me a second. Huh? Okay, I think there's some technical difficulty, but until it goes on, let me just tell you about the exam format about contract law first while I'm trying to connect with the content from the second camera. Let me just explain to you how the exam works for contract law, right? So first of all, yes, so I got it ready. First of all, this is your exam format for contract law, right? Please look at this paper here. Well, you will be given 8 questions. And out of these 8 questions, you have to choose and answer 4 questions. See, different papers will have a different format, but this is actually the format for contract law. Choose and answer 4 questions only. And these 4 questions may range from problem or essay. Right? You have a problem solving question or you'll have an essay question. In a problem solving question, you'll have a fictitious problem like, someone did to someone something, and then you have to advise them, how do they proceed with the law in reliance with case laws, in reliance with the existing statutes and others. And you have to do this within 3 hours and 15 minutes. 15 minutes is traditionally the reading time, right? And 3 hours will be the writing time. So in total, technically speaking, the 3 hours divided by 4 questions, that will be 45 minutes for each question. 45 minutes for each question. But of course, because right after COVID-19, it's no longer 3 hours, 15 minutes. it is now the exam being done for 4 hours, right? So you have more time. But by right, although it's 4 hours, but because it's an online exam, so they will say that the 4 hours is for you to upload your outlines, the exam answers, right? So technically, the exam is 3 hours and 15 minutes, even until today. But why they give 4 hours? Because you're supposed to upload the exam question right after your exam, and not everybody will have access to high-speed internet connection. Some of them will have a very normal connection, right? So it may take some time for them to upload it. However, some students will utilize these 4 hours completely. Some students will go on and write the exam answer for 3 hours, 55 minutes. Well, University of London won't do anything about it. As long as you upload it within 4 hours, then it's fine. So if you're confident over your internet, if you think that, your internet is a high-speed internet, you can actually upload it within time. Actually, it's just few kilobytes documents, right? So you can actually even utilize 3 hours and 50 minutes. But by 4th hour, you should have uploaded everything. You understand this, right? So that's the exam format. The second thing that I want to tell you is about the books that you're supposed to look at. Well, this is apart from the notes and the outlines that I'm giving in class, right? I'll be giving you some notes. I'll be giving you some outlines in class. We will be looking at my notes and my outlines in class very frequently. However, if you look at your subject guide is actually a book that you can refer to when you register with University of London. They will give it to you in online form, in a PDF Word. So in that subject guide, so the first thing is you should look at subject guide, ideally speaking. The subject guide will guide you throughout the entire subject matter. So for an example, if you have a question, right, you don't know whether this is actually something, whatever you are studying or whatever you are reading elsewhere is part of your syllabus or not. You don't know that. If you don't know that, how do you know whether it's part of your syllabus? You look at the subject guide. Whatever in the subject guide is in your syllabus. Whatever not in the subject guide will not be in your syllabus. That's how it works, right? So that's in the subject guide, right? And second, University of London in the subject guide has given certain books as essential reading. Essential reading means technically you should have read the book, right? Technically you should have read the book. That's called essential reading. So in essential reading, we have this book called McKendrick. See, all contract law books name will be contract law. I repeat, all contract law books name will be contract law. Only the author's name will be different. So the essential reading is McKendrick. McKendrick Cortex in contract. That's a book name, right? This book is classified as essential reading, which means you must have read it, right? But of course, if you ask me whether is it compulsory to read, no. But it is essential for you to read. By right or by far, you should have actually done it. Then apart from that, there are many other books that considered to be optional reading. Optional reading will be like Anson, Professor Anson on contract. You can look at Jill Poole on contract, right? You can even look at, there are many, right? There are actually way too many books. Anson is a good book. Trital, there's Trital as well. Certain books will be very advanced, very complex. Certain books are quite simple. Like McKendrick is a good book for students. Jill Poole is a good book for students. Anson, you must be careful in reading his book because the views are quite advanced and sometimes it won't be reader friendly because of the usage of legal jargon or bombastic words, right? Then Trital is a very, very, very advanced book. It's even more advanced than Anson, right? So you must exercise some caution before reading Anson and Trital, but other books are good. Then apart from this, if your exam is a closed book exam, well, up to today, we think that it is still an open book exam, but you have to go to the center and do the exam, right? But we don't know whether next year it will be a closed book exam or not. Well, I don't think so, but I don't think that it will be a closed book exam. I think it will be still an open book exam, but this will be only decided in December by University of London. We have no control over this. University of London will decide this. Although I think they do not want any sort of a physical exam, but they will decide this from time to time. So if your exam in a very, very unlikely situation happen to be a closed book exam, then you need a statute book. Statute book is actually a book that contains all the statutes. Throughout the entire contract law, you may have to read about 100, 200 sections. Right? So those 100, 200 sections will be in the statute book. So that you don't have to memorize the 100, 200 sections. You don't have to memorize it. So you may also have to carry a copy of the statute book. University of London stopped giving statute book to students. So depending on your situation, you may wait until December this year. Depending on your situation, you can actually go on and carry statute book if it is a closed book exam. Right? This statute book has to be bought. You can buy book by Palgrave and Macmillan Publisher, or you can buy a book from Blackstone. Blackstone is better. Okay? You have any question over this? These are the preliminary things that you're supposed to know in contract law before we dive into the subject matter. Anybody have any question on what you're supposed to read, or the exam format, or how certain things works? Want me to explain few things? Okay. So if there's no issues, then what we'll do? We go into the first chapter. So I'm referring to your chapter back. Okay, so this is actually the chapter back, the book that you have. Speed must have actually passed you a soft copy of this book. And if you go to the table of contents, you can see all the chapters here, right, that you have in your contract law. So if you see here, so we have how many chapters? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 14 chapters in contract law. Right? And what we'll be looking at today is, we will be looking at the first chapter, intention to create legal relationship. And we'll also go into the second chapter for this whole 10-hour session. Right? We will look at intention to create legal relationship. And we will also look at offer and acceptance, which is actually the second chapter. And then we will look at question. And that will be the end of the first session. First session means I'm talking about all 3 days. Not only today, all 3 days. Okay. So, let me go to the first chapter. In page number 2, you can see the first chapter, intention to create legal relations. Can you see the first chapter? Intention to create legal relations. That's the first chapter. So, intention to create legal relations. Or what do we call intention to create legal relationship? Together with these 3 requirements here. These 3 requirements. If you satisfy this, you have a valid contract. Right? You have to satisfy these 3 things for you to have a valid contract. And I'll explain about this briefly now. See, any contracts that you face in the world, when I speak about contract law, usually, when I go and ask people about what is contract, they will say that contract means it's a piece of paper. People have actually written something on it, and then 2 people will sign, and that is actually contract. But that's not really contract. What is a contract? I mean, that's actually form of a contract. It's part of a contract. What is contract means? Right? Contract is an agreement between the parties. Am I right? No? Contract is an agreement. And what does an agreement contain? You know, we will always use this word. He has agreed to do this. What does it mean? An agreement means it contains promises. I promise you that I will come here tomorrow. I promise you that I'll renovate your house. I promise you that I'll paint this house. I'll promise you that I will repair your car. These are all promises. And when you say yes for the promise, there's an agreement, right or not? So a contract consists of an agreement. An agreement consists of a promise. So a contract is actually a promise, right? A contract is a promise. So let's take into account of your sales and purchase agreement of your house. What is the promise here? The promise by the developer that he will sell this particular house at block C, right? In floor 39, house number 17 to you. In return, you have to promise the developer that I will pay and buy the house. Right or no? You are promising him, he is promising you. That is sales and purchase agreement. So, a contract is a promise. And a promise need not to be written. A promise can be perfectly oral. Spoken contract, oral contract. So, contracts can be divided into two. Simple contract, right? Simple contract. Special contract. Simple contract, special contract. Right? And simple contract means contracts that happens in domestic life. And these contracts are not written, usually. Not signed. Not sealed. Not witnessed. Not written, not signed, not sealed, not witnessed. Sealing is a requirement where you put it in an envelope and you wrap it, right? That's called sealing. Why? Because all these simple contracts are made in domestic life. That's the reason it's not written, it's not signed, it's not sealed, it's not witnessed. Like for an example, the father look at the son and say, son, if you pass the LLB exam, father will buy for you a brand new car. Obviously, the son cannot go and ask the father, please put this in writing. Why? Because it will break the relationship. So most of the time, simple contracts are not written, not signed, not sealed, not witnessed. Why? Because it happens between family members. It happens in the domestic life of family members. Whereas special contract, in contrast, special contracts are always written. Special contracts are always signed, always sealed, always witnessed. And when do special contracts happen? In professional relationship. Oh, sorry. I think I didn't share that. Right. Special contracts are written, special contracts are signed, sealed, and witnessed. And it will happen in a professional relationship. So, what we are going to study in our first 3 chapters. So, I told you ITCLR, agreement, consideration. These are the requirements to prove simple contract. These are the requirements to prove simple contract, not special contract. Why not special contract? Because in special contract, when 2 parties written a contract, when 2 parties sign the contract, when it's sealed and witnessed, we assume that offer, acceptance, consideration are all satisfied. There's an assumption that everything satisfied. You understand this? So, when do we suppose to satisfy the requirements of ITCLR? Agreement, consideration. When we supposed to satisfy these requirements, that is in simple contract. Special contract do not say that this requirement is not needed. Requirements are not needed, but all these requirements are presumed in a special contract. All okay? So we are going to start from intention to create legal relationship. Okay. So can you see intention to create legal relationship? And you look at page number 2. Page number 3, sorry. Okay, the first question often I'll get. What is this intention to create legal relationship? Right? What is intention to create legal relationship? Well, intention to create legal relationship means in real life, it means intention to sue. Right? Intention to create legal relationship means intention to sue. Sue who? Sue the person who made the promise to you and the person who do not want to fulfill the promise. Right? And it must happen within domestic setting or social setting. Social setting means between your friends. So I give you an example. If your father said, if you pass your LLB, he'll buy for you a brand new car. Right? Now, the thing is, you have actually passed the exam now. And you go to him, he's refusing to buy the car to you. So can you sue him? Well, people will say that, yes, he is the one who came and offered and I accepted the offer. Right? I said that, okay, I will do very good in my exam. And now you are refusing to buy the car. So the first question we will ask, is there an intention to create legal relationship between you and him? What is again intention to create legal relationship means? Intention to sue. Do you have an intention to sue your father? Most of them here will say, no, I don't really mean to sue. Right? He's my God. He's everything to me or whatever. So this intention to create legal relationship or intention to sue, right? Intention to create legal relationship or intention to sue. When we supposed to look at this is the problem. See? So if I draw a timeline, right? This is where the contract starts. This is where the contract ends. Right? And you are here. And there's a bridge. Right? There's a bridge. So when do we supposed to look at whether there's an intention to create legal relationship? See, when there's a breach of contract here, then you will try to sue the person here. Because this is a timeline, right? But when do we supposed to look at whether is there an intention to create legal relationship or not? That is here. Because ITCLR, or what do we call as intention to create legal relationship, has to be decided at the beginning of the contract. At the beginning of the contract, not at the middle, not at the end. It is at the beginning. Because if I stop you when your father promised you a brand new car, if I stop you at that time and I ask you this question, do you think if your father never buy for you a car, would you sue your father? And your answer will be like, are you mad? He's my father. He's everything to me, right? You are jealous of me because you never got such a father. Please be happy about the blessings that I have from the God. You will utter things like this, right? You will obviously utter things like this. But only when the problem arises here, right? Only when the problem arises at here, you would say that, what a life, my father cheated me. You will post in Facebook like, better be alone in life, right? When parents cheat you, what will happen to kids, and put hashtag here, hashtag there. So obviously here, if you ask anybody, do you have an intention to create legal relationship with your father? Again, what is intention to create legal relationship means? Intention to sue. So if I ask you whether you have an intention to sue your father here, your answer would be yes, I want to sue. You will definitely say yes. Why? Because dispute already arises. If your father breached the contract, you would probably want to sue him. But if I ask you here, you would probably do not want to sue him. But what the law says? The law says ITCLR, or intention to create legal relationship, has to be decided at the beginning. At the beginning of the contract. Not at the end, right? Not at the middle, but it is at the beginning of the contract. You understand this? Beginning of the contract. Anybody have any issues here? Okay, second, right? So this is when. And number two is who decides this? Who decides whether there is a ITCLR or not? Intention to create legal relationship. Now, if I ask who, you may say that who means what do you mean? It must be the judge, right? That's what people will think. Of course, at court, the judge decides, but judge is also a human being like us. So if I ask the judge, do you think there is an intention to create legal relationship between the father and son from the very beginning? Probably he will try to look at the relationship between father and son, like how the relationship between him and his son is. So if he and his son is close, he will probably say that, no, I think the son wouldn't want to create legal relationship with the father. Or if the relationship between him and his son is strained, then he will say that, no, I think the son has intended legal relationship with his father. The reason is because the judge would try to associate his situation, his life situation, in order to find out or deduce the answer. Right? So, the court decided. The person who must decide, right? Who must decide? That's an ITCLR. That is a reasonable man. Right? So I'll show this to you in the notes. We go down. Can you see here? The presumption is objectively ascertained. Reasonable man's test. So who is this reasonable man? Of course, please remember, in court, the judge decides everything. Right? There's no dispute on that. But the judge assumes himself as a reasonable man. He has to put himself in the reasonable man position and he has to give an answer. So the obvious question here is, who is this reasonable man? This reasonable man is actually a median in the society. I repeat, this reasonable man is actually a median in the society. What do you mean by median in the society means? A median in the society means he's not so rich, he's not so poor. He's not so idiot, he's not so intelligent. He is average on everything in his life. Everything average. He doesn't have preferences, but at the same time, it's not like, he is like a zombie. Right? So, a reasonable man, if I ask you who's this reasonable man? In UK, they will say this reasonable man is the man in Clapham Omnibus. Have you all seen Omnibus? See, this is what they will say in UK. If you go and ask them, who's this man? They will say that this is the man in the Clapham Omnibus. But of course, in United Kingdom, we don't have Omnibus. Clapham is actually a town. Omnibus is actually the vehicle. I'll show you Omnibus. Wait, okay. Omnibus. Now, this is the Omnibus. See? This Omnibus is also Omnibus. So, wait, let me just explain to you. Can you see here this Omnibus? So, what will normally happen in Omnibus is this bottom of the carriage, the first tier where people can sit, will be so crowded. So, some people will be sitting at the second floor, right? And the second floor is open-ended. First floor, There's a roof. Second floor is actually opponent. And you see the horseman will be sitting from the top and he will be operating the horses. The thing is, this is around 1895. The thing is, omnibus is so congested, so crowded. It is only taken by, a normal person. If you are a bit rich, you have your own horse. So, when we say the man in the Clapham omnibus, Clapham is a locality where omnibus was there. Alright, so omnibus means today in Hong Kong, this is associated to, let's say, a man in the MTR who takes an MTR from, let's say, from New Territories to Central every day. He has to come from New Territories to Central every day. And, at morning peak hours, MTR will be so congested. Right or not? So this is the man who's hanging in the MTR from New Territories to Central every single day. He is actually an average man on everything. Right? He's an average man on everything. Such a man doesn't really exist. He is actually a legal creation. And that man must decide whether there is an ITCLR or not. Anybody have any question? That is reasonable man's test. Anybody have any question to me? Okay. So what the law presumes is this. See, the law divide this into two. Domestic category and commercial category. In a domestic category, right? In a domestic category, 3 steps has to be followed. Similar as a commercial category. Step 1, right? Or first thing is, if it is a domestic category, then the presumption that the law makes here is there is no ITCLR, intention to create legal relationship. But this can be rebutted. In a commercial category, the presumption is there is always ITCLR. But of course, this can be rebutted as well. So there are 3 steps you must remember. First thing, you have to look at what is the category. Second thing, you have to look at what is actually the presumption. Third thing, you have to look at whether it can be rebutted. Right? So what is this domestic? Domestic or social category? Domestic or social category means category between the family members, friends, work colleagues, right? Parents, cousin, niece, extended relations. All these people will come under domestic or social category. And in domestic or social category, the presumption is there is no ITCLR. Why? Because the law presumes that, right? The law presumes that normally there will be no intention to create legal relationship between family members. Because you realize this throughout your life, right? Throughout your life, in your family, you will see multiple sweet words will be thrown. Because father wants to make the son happy, because the son wants to make the father happy, right? There will be multiple sweet words will be thrown. But not all sweet words are meant to be enforced. Not all sweet words are meant to be enforced. So, the general presumption here is if it is a domestic or social category, there's no ITCLR, but it can be rebutted. Rebutted means the court will now say, the moment the court asks you, what is the category? You will say that he is my father, or father's son. Okay. So, which means second, presumption. This is a domestic category, right? Meaning, there's no ITCLR. Go back home. I go back home. However, you will say that no, despite of the fact that he's my father, I still want to sue him. I still have an intention to create legal relationship with him. That means the presumption is rebuttal. Rebuttal means you are bringing an evidence to go against or counter the other evidence. Do you understand this? Anybody have any problem? Anybody wants to ask me any question? All okay? Okay. So that's domestic or social category rebuttal. We will look at some cases here, right? We are not done with this area. Then commercial category. Commercial category means the agreement between you and your boss, the agreement between you and your, the person, your client, the agreement between you and your customers, right? These are all considered to be commercial category. And in commercial category, the presumption is there's always ITCL. Because let me ask you a question. If your boss never pay you, right? If your boss never pay you for, let's say, 1 month, and if I come and ask you, do you think you would sue your father? What you do you think you would sue your boss? What your answer would be? You would say definitely yes. But the same thing cannot be said, right? The same thing cannot be said for domestic contracts. Sorry, for commercial contracts. Right? Why? Because the same thing, the same thing cannot be said for domestic contract because in commercial contracts, that person is your boss. And you just want to be in a commercial relationship with him. If he never really pay you, you would sue him. That's all. If he never really pay you, you would sue him. But in domestic contracts, you won't because you'll be thinking that, he's my father, whatever happens, he's still my father, things like that. So in commercial category, the presumption is there's always ITCLR. And if you want, you also can bring evidence to rebut it, to say that despite of the fact he's my boss, and this is a commercial category, I still do not want to sue him. You can bring an evidence and rebut it. Do you get this? Anybody have any issues? Okay. So please remember these three things are very important, right? The three things are what is the category, what is the presumption, and whether it has been rebutted. What is the category? What is the presumption? Whether it has been rebutted. Right? Okay, so we are going to look at some cases now. We are under the first one. Domestic or social agreements. Can you see that? Domestic or social agreements. So what did I say to you? In domestic or social agreements, the presumption is there is no ITCLR, right? There's no ITCLR. Okay, so the first case that we want to look at, agreement between husband and wife, right? And the first case that I want to look at is the case of Balfour and Balfour, 1909. The case of Balfour and Balfour, 1909. So Balfour and Balfour, 1909. This is what happened in that case. You can see the facts, but I'm going to explain to you the facts. So husband and wife, they are a romantic couple. They are in a good relationship. Husband got a job in Ceylon, which is now known as Sri Lanka. Right? Once upon a time, it was known as Ceylon. So the husband wants to go to Sri Lanka. Wife also followed him. Right? And after a while, they came back to UK for a holiday. And when the husband want to go back, he called the wife, but wife said, I'm not coming. So husband asked why. He said that, I don't like the way they cook the food there. I don't like the temperature there. And, I also feeling severely sick. Right? I'm not really feeling well to come to Sri Lanka. So the husband said that, okay, fine, no problem. while we are apart like this, I am there, you are here and all right, I will give you 30 pounds per month as a maintenance payment for you to take care of yourself. So the husband went to Sri Lanka. Actually, there was an evidence indicating that for the first month, the husband really paid. The husband paid the money. But on the second month, he found a new lady in Sri Lanka. So the husband told the wife that I'm not going to pay you any longer. The wife is very upset and the wife went to court. So the court asked a very simple question, right? They didn't complicate or anything. So here, I'll ask you. Same question. What is the category? Husband and wife, domestic. What is the presumption? No ITCL. Can this be rebutted? Do you have any evidence to say that despite he is my husband, but I still want to sue him? No, nothing. Right? You don't have any evidence. Because at that time when the promise was made, you did not tell your husband anything. Right? At the time when the promise was made, you just told your husband, thank you so much. You are the best husband in the world and things like that. But you did not tell your husband that, if you never really pay me, I will sue you. Why you didn't say so? So the wife failed in her course of action. The wife failed in her course of action because the presumption works against her. There's no intention to create legal relationship. Again, what is intention to create legal relationship? What I say? Intention to sue. Intention to create legal relationship means intention to sue. There is no intention to sue here. Because at that time, see, I just told you, right, when we supposed to look at intention to create legal relationship, at that time when the promise was made. At that time when the promise was made, the husband and wife both were in a good relationship. And who must decide this? A reasonable man. And the reasonable man would say that, the husband and wife, when the promise was made, they were in a good relationship. So can you see what Lord Justice Elkin stated? See, hell, CA. When you see the word CA just appears like this, CA means Court of Appeal. Right? CA means Court of Appeal. Court of Appeal. That's what CA means. Do you understand this? So look at what Lord Justice Atkin stated. The defense to this action on the alleged contract is that the defendant, the husband, entered into no contract with his wife. And to the determination of that is necessary to remember that there are agreements between the parties which do not result in contracts within the meaning of that term in our law. There are agreements that is not really a contract. Why? Because in order to create a contract, I told you, you have to satisfy 3 requirements just now, which is intention to create legal relationship, agreement, and consideration. So all agreements are contract, but not all, all contracts are agreement, but not all agreements are contract. I repeat, all contracts are agreements, but not all agreements are contract because you also have to satisfy ITCLR, you also have to satisfy consideration. So if you fail under any one, we can actually say that there's no contract. Do you understand this? Anybody have any issues? Okay. You go down. You can see the case of married and married. Right? Can you see married and married? In married and married 1970, almost similar facts to Balfour and Balfour. In married and married, see again, I would like to tell you this. When you see this case name, right? See, it says Balfour and Balfour. Balfour and Balfour does not mean Balfour is suing himself. Balfour and Balfour means Mrs. Balfour suing Mr. Balfour. Please remember, you can't sue yourself in any court, right? You can't sue yourself in any court. So it's Mrs. Balfour suing Mr. Balfour. That's why the case name is Balfour against Balfour. You get this? Okay, so we go down. You see Merritt and Merritt again. This is Mrs. Merritt suing Mr. Merritt. Okay, there's a question. How to pronounce the V? Okay, that's a very good question. Okay, there's a question here asking me how to pronounce the V. Okay, see, some people will pronounce this as versus, right? But this is V, this is not VS. VS can be versus, but this is not versus. There's no boxing match here for you to say that Balfour versus. If it is criminal law, you will use the word Balfour against Balfour. The word against, right? If it is criminal law, usually in criminal law, V means against. In civil law, which includes contract law is civil law. V means N. That's the reason you can see I'm pronouncing Balfour and Balfour, right or no? It's not Balfour against Balfour. It is not Balfour versus Balfour. It is Balfour and Balfour. All civil cases, the word V, right? The alphabet, not word. The alphabet V indicates N. Balfour and Balfour, meaning Balfour suing Balfour. That's what we call as Balfour and Balfour. Right? That's how you're supposed to pronounce it, the V. Balfour and Balfour. Okay. No problem. You're welcome. Okay, so I think I missed the page. So in page number 4, you can see the case facts of Merritt and Merritt. Again, Merritt and Merritt is Mrs. Merritt suing Mr. Merritt, the wife suing the husband. So this is what happened. In Merritt and Merritt, the husband and wife is going to be divorced. They are not divorced yet. Until you get a divorce, you are still considered to be husband and wife. So you have already proceeded with divorce, but you are not divorced yet. So when the husband divorces the wife, the husband has to pay some alimony. Alimony is actually a compensation given by the husband to the wife. So the problem here is the husband don't have money to pay alimony. So the husband called the wife and said, see, I can't really pay you alimony. Alimony has to be paid monthly compensation. So the husband told the wife, if you actually settle off the balance payment of the house, they were paying for house installment, there have been some balance. So the husband said, you pay off the balance payment, I will transfer the house under your name. Right? This was, see, during a conversation in a car, the husband promised to pay the wife for more than 40 pounds a month. In return, the wife must pay the outstanding mortgage payment on the house. Right? And so what the wife said, so technically you have to pay alimony and he has no money. So he said that you pay off the monthly payment. You pay off completely. I transfer the house and I will have some money from the sale. So out of which I will pay you more than 40 pounds a month. Right? Lesser than 40 pounds, sorry. Lesser than 40 pounds a month. So the wife asked the husband, put this in writing. See, in Balfour and Balfour, the wife did not ask the husband to put this in writing. But in this case facts, the wife asked the husband to put this in writing. Why? Because the wife knows that the husband is a cheater. Second thing is, they are in a divorce proceedings. When you are in a divorce proceeding, obviously, your relationship is not so good. Right? When your relationship is not that good, and when you are in a divorce proceedings like this, it's you don't trust each other. That's the reason you want to put this in writing. You don't trust each other. Okay. So what happened was the husband put this in writing. Then after that, the wife transferred money to settle off the entire mortgage payment of the house. But after she did so, the husband refused to transfer the house under her name. So the wife initiated a legal action against the husband and to court. Again, Court of Appeal. The ICA means what? Court of Appeal. They stated that the parties had intended legal relations. The husband was liable under that action for breach of contract. Why here the court is willing to enforce the contract? If the court willing to enforce the contract, meaning there's an intention to create legal relationship, right or not? Because I told you, if you said never satisfy requirement number 1, there's no contract. You have to satisfy all 3 requirements: agreement, consideration, intention to create legal relationship. These are all your first 3 chapters. Just now I was showing to you in the table of contents. Okay, so why? Why here there's an ITCLR, but why just now in Balfour and Balfour there was no ITCLR? What is the difference? The first difference, you can see under the comment section, the first difference is, in Balfour and Balfour, the couple, they were in a good relationship. The case that we have looked at just now. They were in a good relationship when the promise was made. But in Married and Married, they were already in a divorce proceedings. They're already in a verge of separation. Only then, right? Only then, this promise was made. So obviously, whatever you say when you are at the verge of separation, you will mean it. Right? You will mean it, whatever you say. You will definitely mean it. So, the court stated it's because one party was in a good situation, another party in a bad or strained relationship. That's the reason we can take Married and Married as there is an ITCL. That's the first thing. Second thing, the court stated, the promise was put down in writing. It was put down in writing. Normally, when you write something, we will always presume there is some seriousness attached to that. Right? There's some seriousness attached. Right? So, in Balfour and Balfour, there was nothing in writing. But here, there was something in writing. And number 3, all the terms of the contract are clearly indicated. When you're supposed to pay, everything is there in Married and Married. But in Balfour and Balfour, it was a casual promise. You never even say when you're going to pay for it, right? How you're going to pay for it. Nothing was certain. And therefore, the court stated, in Balfour and Balfour, there is no ITCLR. But in Married and Married, there's an ITCLR. So the difference is, technically the difference is, here the parties are in a divorce proceedings. There the parties were in a good relationship. That's the difference. Anybody have any issues? Can you distinguish and see the case of Married and Married in Balfour and Balfour? What has actually gone differently? Because you must know the difference. When you explain to the examiner, you must able to tell them why the case of Married and Married was decided differently compared to the case of Balfour and Balfour. Right? So when you say this to the examiner, it will be very impressive. Anybody have any issues? Balfour and Balfour, Married and Married, all okay? Okay, that's a great start. Remember Balfour and Balfour, Married and Married. It's actually a very, very important precedence. Right? So every student must know this. These are likely to be the first two cases that you have studied as well. Okay, then what we supposed to do? This is actually, merit and welfare and welfare. These are actually agreement between husband and wife. But some people, they live like husband and wife, but they are not known legally as husband and wife. There's a situation of prenuptial agreement. Those who are living together. How the law works here? Is there an ITCLR or no ITCLR? But before that, I'll give you a quick break. We will meet after the break. Right? Please take a break. After the break, we'll go on and continue with prenuptial agreement. Right? Take a break. Okay, I'm back. So before the break, I've looked at the case of Balfour and Merit. Right? I've looked at the case of Balfour and Merit. And we have looked at the differences between these two cases. In Balfour, the couple, they were married. Even in Merit, they were married. But the difference was in Balfour, they were in a good, healthy relationship, whereas in Merit, they were in a strained relationship. So if you look at whatever I've actually given you as a guideline, I'm merely following that. I just want to show to you that I am following that. See, this is what I told you. The first thing you have to look at is, what is the category? What is the category? Domestic. Although you are in a divorce, you have already applied for a divorce. It does not mean that you're already divorced. So the category is still domestic. Until you get divorced, the category is still domestic. The second is the presumption. So if the category is domestic, what is the presumption? No ITCLR. And number 3, can it be rebutted? Yes, it can be rebutted. So number 1, the category is domestic. The presumption is there's no ITCLR. And number 3, it can be rebutted. Do you understand this? All okay? Okay, so can there be a rebuttal here? In Balfour, there was no rebuttal because they were still in a good relationship. But in Merit, she could able to show that, no, I'm in a divorce. I have, although I have never obtained divorce, but I have already applied for a divorce. So that was taken to be a rebuttal factor, meaning to say that you can displace the presumption. You can create ITCLR. Although the law says there's no ITCLR, you can create ITCLR by showing this type of evidence. Right. So now what we will do, we'll go on and look at prenuptial agreement. Can you see prenuptial agreement? The heading prenuptial agreement. So increasingly nowadays, you'll realize that people are living together without getting married. We call that in law as a cohabitation, cohabiting couple. Right? If you are living together without getting married, then we will say that you are in cohabitation. Cohabitation in United Kingdom, it is not illegal. But at the same time, it is not legal. What do I mean? They don't really care if you are living together without getting married. They don't really care. But why I say that it is also not legal, it's because when you die, the other person's property does not immediately or will not immediately comes to you. Either you should have written a will. If you never written a will, then by following intestacy law is the law that is applicable if you die without a will. And in intestacy law, the property will pass to the spouse. And the spouse means husband or wife. So if you never get married, you are neither husband nor wife. And therefore, you don't get the property. That's the reason I said, if you never get married but living together, it is not illegal in UK, but at the same time, it's also not legal in UK. But they won't disturb you, they won't do anything, right? You are free to live, but it is just when anything happens to either one of you, it will be a problem. Unless you have written a will or you have already passed the property via, other legal instruments. So prenuptial agreement is a different type of an agreement. See, if I ever ask you, what is the most serious contract that you can engage upon in your life? What is the most serious contract? The most serious contract in this world is marriage. Because marriage is also the most difficult contract to get out from. Why marriage is so serious? Because it's so difficult to get out from marriage. If you don't want to be a student of speed, you just have to inform speed, and you don't pay. Just have to send a withdrawal letter. But If you don't want to be the husband or wife to somebody, you cannot simply tell them that I'm not going to see you, I'm not going to talk to you, I'm not going to eat the food that you cook, I'm not going to take care of our children, I'm no longer your husband. You can't say that. Even if you decide today to get a divorce, it will take minimum of 1 year to 2 years. So marriage is very serious because it is very difficult to get out from marriage. But if you take into account, if you go back and see your marriage certificate, see, marriage certificate is a contract, right? It's a contract that you agree to live with this person until divorce or until you die, whichever comes first. Am I right? But being so serious contract in this world, what are the terms of the marriage? Is there any clause 1, clause 2 for the marriage? Who pays for the car? Who pays for the house? Who pays for the kids' education? Who pays for kids' pocket money to school? Nothing was indicated. Nothing. That's the reason we say marriage is actually, I'm not trying to say marriage is silly, but marriage contract is very silly. Because you are entering into a contract with someone, for most people, they will say it's a lifelong relationship. But you don't know what are the clauses. Such a serious contract, you don't know what is term 1, what is term 2, what is term 3, you don't know. So some people, what they will do, they will get into this prenuptial agreement. Prenuptial agreement, or at certain times you will see they will call this as a post-nuptial agreement. Right? These are all the same. Prenuptial, post-nuptial, these are all the same. Antenuptial, yeah. Antenuptial also same. Okay. Antenuptial. Right? These are all indicating the same agreement. This, before you get married, you will get into a contract with your husband or wife, indicating who pays for the car, who pays for the house, who pays for electricity bill, who pays for the car bill, everything. You get this. Okay, so whether this prenuptial agreement can create ITCLR or not? That is the question here. Can a prenuptial agreement creates an ITCLR? That is the question. Do you understand? Okay, so let me look at this case. Red Masher against Granatino. This is applicable for people who lives in relationship. But prenuptial is always entered upon for people before they get into contract. But in certain cohabiting couples today, they will just get into certain agreement like this. But this type of agreement is allowed or not? That's the question. You can get into this agreement if you're going to get married. You also can get into this type of agreement and you live together without getting married. So I'm just trying to look at whether this type of an agreement is valid or not. Or this type of agreement will be enforceable in court. It will be only enforceable when there's an intention to create legal relationship between both of you. Or what the law is, if you're husband or wife, or even if you are living together, if you are living together, thinking that the other person is taken as a husband or taken as a wife, then definitely, you can't say that there's an ITCLR, because that's also a domestic contract. You don't have to marry to someone for you to make the contract as domestic. Like between you and your sibling, it's a domestic contract, but you're not married to your sibling. You and your cousin, you and your nephew, you and your niece, you're not married to them, but it's a domestic contract, right? So, would this type of contracts are enforceable? You can see the case of Red Masher against Granatino, 2010. So, the husband and wife both were married. The husband is actually a middle class, average person. Wife is a filthy rich lady, so rich. So, the wife have actually asked the husband, they got married here, right? The wife have actually asked the husband, let's get into an agreement. What was the agreement? The agreement was this. See, the agreement here was subject to German law and provided that neither party was to acquire any benefit from the property of the other during marriage or on its termination. That means while we married to each other, you won't get any of my property or any benefit out of my property. right after termination of marriage, meaning whether by death or whether by divorce, you also won't get anything from me. Of course, this is applicable mutually between the husband and wife, but obviously the wife is so rich. So the husband is the one mainly targeted here. The husband won't be receiving anything, even during the marriage or even upon termination of the marriage. So the husband did not really bother so much about this agreement because apparently uh, the wife told the husband, if you agreed to this, there will be some money given by family members to you, right? Or to our family, which we can make use of. So husband also went and signed. Uh, he also did not discuss any lawyers, nothing whatsoever. He's not an idiot, he's actually a banker. And what happened? The party separated in 2009. Divorce. So the husband went and asked, where's my compensation? Right? Because technically husband has to give wife compensation. But in this case, the wife is so rich. So the husband wants some sort of money from the wife. So the husband was actually suing for 5.5 million pounds after the breakup. By right, if not for that agreement, he's entitled for that because the wife is the one who wants a divorce here. But because he signed such an agreement, the court stated this. See, Supreme Court upheld a decision that the husband was not entitled to an award 5.5 million after the breakup of the marriage because such an award would give insufficient weight to the prenuptial agreement. Meaning, you have agreed. If he give you 5.5 million, it means we are not really enforcing the prenuptial agreement. So the problem is, see here, if you follow whatever I've given to you, see, between husband and wife, the category is domestic. Presumption is there's no ITCLR. This is automatically the law presumed. Can it be rebutted? Apparently, yes. That is the antenuptial agreement. The antenuptial agreement shows that the husband and wife has intention to create legal relationship. Because you take a survey of statistics, how many people have gotten into such an agreement? Close to none. So the fact that you have got into such an agreement shows that you have an intention to create a legal relationship. And therefore, we have to enforce this agreement. And also it means you had an intention to create legal relationship to come up with this agreement as well. So the fact that antenuptial agreements are actually enforced, this shows that the court is more willing to presume. I mean, of course, there's no IGCLR, but the court is more willing to accept antenuptial agreement as a rebuttal factor. Do you get this? Anybody have any question? All okay? So the same thing is actually taken. The same stance will be taken for post-nuptial agreement. Post-nuptial means after the marriage. Prenuptial before the marriage. Another name for prenuptial is antenuptial. Any issues? Okay, that is an agreement between husband and wife. But in the same line, how about those who never get married but living together in cohabitation? How it works for them? How it works for them? Okay, so you can see here, in Tanner and Tanner, unmarried couple lives together. When unmarried couples lives together, the court more likely to consider that agreement relating to property or separation or formal arrangement would be enforceable. Meaning to say, category here is domestic. Presumption is no ITCLR. But the fact that they never get married, according to the court, it will create it will create an ITCLR. It's like a rebuttal factor, the fact that you never get married. So anything that an unmarried couple decided or any agreement that they get into will be enforceable. Right? Because the fact that they are not married considered to be a rebuttal factor to the court. Do you understand this? So this is between husband and wife. Anybody have any issues? This between husband and wife. And now we go to agreement between parent and child. You see agreement between parent and child. In agreements between parent and child, similar to husband and wife, there's no difference between the presumption of law. See, the presumption of the law is the same. We look at the category mother and son, or father and son, mother and daughter, father and daughter. These are all domestic category. The presumption is there's no ITCLR and it can be rebutted. In domestic category, all the presumptions are the same. Right? All the presumptions are the same in domestic category. You get this? Okay, so we'll go on and look at Jones against Padavatten. Can you see Jones against Padavatten? 1969. Okay, Jones against Padavatten is mother and daughter. All right, Jones against Padavatten is mother and daughter. 1969. Mrs. Jones, she's the mother, right? And she called her daughter to come and stay with me. And, you know, mother's alone, mother is very old. So I can't do anything on my own. Please come and stay with me. That daughter said, no, mom, you know, I'm actually working. The daughter is actually not like a small child or what. The daughter is already married and got divorced, single mother. So the daughter said, no, I'm a single mother. I had to work. I have a daughter on my own, right, for me. And I had to also take care of her, not daughter. She has a young son, right? So she said that, no, I also have to take care of my son and all. So Mrs. Jones said this, okay, no problem. You can come and stay in my house rent-free. You don't have to pay me any rent. Until you pass your bar exam. The daughter studied law, but she is now sitting for bar exam. So she said, until you pass your exam, you don't have to pay me anything. But then the daughter said, okay, that's fine. But how about my pocket money all? How am I supposed to pay? Because if I don't work, I cannot afford anything. So the mother said, okay, no problem. We also have other rooms in this house. We rent the other rooms. And the money that we get from the other rooms, we will actually, I'll pass it to you. You can use it for yourself and for your son. So her daughter also said, okay, no problem. Her daughter came and stayed with the mother. On the first attempt, the daughter failed the bar exam. When the daughter failed the bar exam, the mother asked her to get out of the house. No. The daughter said, you told me until I pass the bar exam, I can stay for rent-free. But the mother said, no, please get out of the house. Now, this none of what the mother told the daughter was recorded in writing or whatever. So right now the daughter is at court, right? And the daughter is suing the mother. So the problem here is there an ITCLR? Right? That's the problem. This is what the court stated. Can you see Health CA? Dankworth and Fenton Atkinson, Lord Justices, thought that neither agreement was intended to create legal relationship. No ITCLR. The presumption failed to be rebutted. There's no rebuttal factor. Why? This is because the agreement was one of those family arrangements which depended on the good faith of the promises which are made and are not intended to be rigid binding agreements. It's very simple. What is the category? Domestic. What is the presumption? No ITCLR. Is there a rebuttal factor? Nothing. I cannot find anything. Did you tell the mother, can you put this in writing? No. Did you tell the mother, I would sue you if you were to chase me out? No. Of course, your mother told you until you pass the bar exam. But now we are trying to see there's no intention to create legal relationship, meaning there's no intention to sue. When we supposed to look at this? At the beginning of the contract. Who's supposed to decide this? The reasonable man. This looks like a family type of a emotionally instilled agreement. That's all. Do you understand this? The court also stated this. Salmon Lord Justice also found Miss Jones, the mother, but on a different reasoning. What was the reason? He felt that the first agreement was a contract to design for to last for a period reasonably sufficient to enable the daughter to pass the bar examination. The mother could not be reasonably be expected under the contract to pay the allowance for the daughter for the rest of her life. Yes, of course, the mother said until you pass the bar exam, you can stay. But that does not mean that you'll be failing the bar exam for 10, 20 years and leaving there for rent free. So, as per the court, one time failing the bar exam is enough. One time failing the bar exam is enough for the mother to ask you to get out of the house. You understand this? You may think the law is cruel, but the law is not cruel. We cannot be enforcing all the domestic agreements. We can't do that. Why we can't do that? Because, see, the court is actually the upholder of the morality. Me, as let's say, if I'm the judge, I have to uphold the morality in the society. Because I'm like the guardian of the morality, right? If I'm a judge, I'm the guardian of morality. I cannot be enforcing this type of cases to destroy the morality in family. So does it mean that after this, every time everybody will sue their family members? There are certain matters that has to be resolved within the family. Don't bring that to the court. Don't. Because it's supposed to be resolved within the family members. Cannot be brought to the court. Do you understand this? That's between mother and son. So for husband and wife, we have looked at some cases like the case of Tanner and Tanner. People were living together, right? Then Writ Masher against Granatino, the effect of prenuptial agreement. Then we have looked at, the case of Balfour and Balfour, married and married. And then now for mother and daughter, we have looked at the case of Jones against Padavatten. And what about other relationships, other social agreements? Simkin and Pace. You see Simkin and Pace? I'll tell you the facts of the case. This is what happened in Simkin and Pace. This is granddaughter, grandfather, friend. Before the arrival of iPhone, iPad, things like that, what people were doing? They will read newspaper. In newspaper, there will be one competition. They will participate in the competition. This is what will happen, right? This is before the arrival of iPhone or any other phone. So this granddaughter, grandfather, and friend, all three of them fill up a crossword puzzle in a newspaper. There was a crossword puzzle they fill up, but in that paper, there's only one name can be written. One name. So all three of them collectively decided we put the name of the granddaughter. Right? Put the name of the granddaughter. And the agreement was if she wins, the reward or prize money will be shared. Will be shared by all three. If she wins, the reward will be shared by all three. You understand this? So they all have actually decided put granddaughter name. But then granddaughter don't have money to even post it, because granddaughter is actually a little girl. She don't even have money to actually post it to the newspaper. So what happened? The granddaughter, grandfather, and friend, all three of them across the board shared money. Granddaughter chip in some money, grandfather chip in some money, friend chip in some money. They shared money and they've paid for the postage for the letter, and they sent the letter to the newspaper. Okay. Once they sent the letter, the granddaughter won. But the granddaughter now refused to give the money to the grandfather or friend. What was the agreement? The reward will be shared. So the problem now is, can they win? The grandfather and the grandfather and the friend. Can they win? This was actually the facts of the case. Can you see Hell? Salas J. Look at what the court stated. Hell, Salas J. There was an intention to create legal relationship. Surprisingly. Why? The defendant must pay the plaintiff tenant. Although Salas J identified that there are agreements between family members and friends which are rough and ready statements, which would not establish the contract, his lordship nevertheless rebuts the presumption. Why the presumption is rebutted? Because this is actually grandfather, granddaughter, domestic. Grandfather and friend, granddaughter and friend is social. Friend is social agreement. Social agreement means the same presumption applicable. No ITCLR. But then why there was an ITCLR here? Because the court stated there was a mutuality in the arrangements of the parties. What is this mutuality in the arrangement of the parties means? Mutuality means what? Meaning quid pro quo. What is quid pro quo means? Something for something. Quid pro quo means something for something. Do you understand this? It's something for something. What is something for something? In contract law, whenever I give you something, it must be for something else. There must be a mutual benefit in contract law. That's why, see, take into account of any contract. I give you something, that is, let's say, a product that I sell to you. And in return, you give me something. That something is money. Contract law is always something for something. So what is that something here? The something is, I will share the reward price. And in return, what you have given the granddaughter? You have shared the postage price. So there was a mutuality. See, I give you an example, right? You see whether it makes sense to you, right? You know, if you want to buy a house in Hong Kong or anywhere in the world, they will ask you for a deposit, right? They will ask you for a deposit, correct, right? Why you need to pay deposit? Let's say after paying the deposit, can you ask them, can I get the key of the house? You can't. Because you have to pay, let's say the deposit is 10%, let's say. You have to pay the balance 90%, right? Then only you will get the key of the house. But why you are paying that 10% for? Because most people will buy house in loan. And technically, you know, if let's say you go to a developer and you say that, okay, I want this house at the 39th floor, unit number 40. Then the developer will say that, okay, you pay, let's say, a booking fees first. Okay, let's say don't go into deposit. Let's say you pay booking fees first. Right? You pay booking fees or even deposit. And then the balance you can pay via bank loan. So what is this deposit booking fee for? Technically, I don't have to wait for you. But I'm waiting for you. That is something I'm doing to you. So you have to give me something else. What is that? That's a booking fee deposit. So that when you come back with 90% of loan, I cannot reject your request. I must give you a unit in the 39th floor, 40th unit. If you never pay deposit, or if you never pay, booking fee, Technically, I don't have to wait for you. I don't have to do this because why should I wait for you? If let's say the next purchaser is a cash purchaser, I can just simply sell the house to him. Right or not? So, in contract law, every time you will realize when you do something, something else must comes to you. On the fact that something is reward money will be shared. And in return, what is that something else? They paid the postage price. So the court stated, because postage price was shared, that indicates there is an ITC. Anybody have any question? All okay? Okay, that's great. So now we'll go on and look at New Testament church. So just to show you, just now I already read this to you, right? Okay. New Testament Church of God against Stephen, 2007. You can see this word here, EWCA. I will tell you what is this citation means. Right? Because sooner or later you have to learn all these citations. So it's very important for you to know the citations. So what is EWCA means? Means England and Wales. England and Wales Court of Appeal. CA means Court of Appeal. So it's England and Wales Court of Appeal. CIV means Civil Division. And then what is that? 1170. No, 1004 means 1004th case of the year. Of the year 2007. Because if you look at the case here, it's 2007. So it's EWCA means England and Wales Court of Appeal. CIV is Civil Division. 1004 means 1004th case of the year 2007. That's what it means. Do you understand this? So it's important for you to know this, remember? I am not teaching this for no reason. It's important for you to remember. Okay, so in New Testament Church of God against Stephen, this is quite a controversial case. I will explain to you the case facts. See whether you understand the case facts. The case facts goes this way. There's this person called Stephen, right? He is actually a priest. It was a Catholic. No, it's not Catholic. It's a Protestant church, right? It's a Protestant church, and this person is actually a priest, but he is not really like a salaried priest or something. He's a freelance, right? He's actually a freelance priest. So what happened? Always the church will call him, and for whatever work that he is doing, he will get paid. But then this time the church didn't pay him. So he thought that there was a delay or something. Then after that, the next day, he went and confronted the management. And the management was telling that, you have to wait and, this and that. But last time all it was fine. Now they are making some problem. There was a delay. So he couldn't able to take it because it was too long already. So what they did? They went and, he went and initiated a legal action. Right? He went and initiated a legal action against Stephen. Sorry, against New Testament Church of God. He went and initiated a legal action against New Testament Church of God. Stephen is actually the priest. Right? Stephen is actually the priest. Just give me a second. Okay. So, it went to court. And in court, out of sudden, the court stated this, which is unbelievable, right? This is what the court said. The Court of Appeal held that in ascertaining whether or not there was sufficient intention to create legally binding contract of employment, Considerations would vary from profession to profession. Consideration would vary from profession to profession. What does that mean? Meaning, in order to find ITCLR, we have to look at profession to profession. Is this really a right statement? Do you think a profession will change ITCLR? In fact, if you look at this is not even a domestic category. They called you and therefore they have to pay you. Am I right or not? If they call you, they have to pay you. This is not even a domestic category if you ask me. This is actually a commercial category. It's not a domestic category. If they call you, right? If they call you, they have to pay you. That's all. Very simple. So it went to court. And court said this. Contract law is an objective question. It's not subjective, it's objective. You know, there are two types of tests. Subjective test and objective test. Subjective test means from your point of view. Do you think what you did is wrong? Things like that. Objective point of view means from a third person point of view. If you are playing a computer game, this will make much sense. Objective point of view means from a third person point of view. So you can see the shooter will be completely visible. The entire shooter, you can see as he is moving. You can see his entire appearance there. Whereas in a first person shooter, you will see only the gun because that's you, right? You are chasing like that. Subjective view is where you see the gun like this. Objective view is you are seeing the person running. That's actually third person point of view. So technically, contract law is a third person point of view. That's the reason we are bringing in reasonable man. If you are telling that we will go from, whether there's an ITCLR, it depends on profession to profession. Meaning, you are taking the subjective intention in the industry. But in contract law, we don't take into account of subjective intention. You look at the next statement. In the case of minister of religion, spiritual duties. Minister of religion is like, priest, right? Spiritual duties did not in themselves preclude an intention to create legal relations between the minister and the religious institution. Yes. The religious belief of the religious institution might be of assistance in determining whether or not there was sufficient intention. The religious belief of the religious institution might be of assistance in determining whether or not there was a sufficient intention. So, he's telling that we should go and ask that religious institution whether there's an ITCLR or not. If they think that there's an ITCLR, that is an ITCLR. Meaning you are making the text subjective. If you're asking one by one like this, it means the test is subjective. The test is not objective. The test is subjective. Am I right or not? Do you understand this? So, why the church came up with this particular argument? Because the church said, you are a priest, right? If you are a priest, how the society will look at you? You are a, highly a moral person, and because you are closer to God than me, so you must be a very spiritual person. That's the impression that I give, right? That's the impression. And certainly, you are telling me that, I want to sue you. So the question here is, would God sue? No. Why? Because we always say God is the most compassionate, the most gracious person. The most gracious, the most compassionate. So if you are closer to God, you must be also compassionate, you must also gracious. So technically the church is telling there's no ITCLR. This is not really a professional contract. This is just like a domestic contract. In domestic contract, the presumption is no ITCLR. And it cannot be rebutted because there's no rebuttal factor here. Remember, the lesson that we learned from this case is, you cannot actually go on and ask religion to religion whether there's an ITCLR or not. Because certain religion will have different beliefs. Certain other religions will have different belief. We only have to ask reasonable men. Am I right? Because religion is very subjective. Religion is a subjective world. Nobody gonna judge you if you never go to church every week. Nobody gonna judge you. Why? Because some people will say that, I don't have to go to church, but God is closer to me. You would accept that. Because religion is actually a personal experience to everybody. So, in my opinion, technically, I have a criticism against this case. You cannot mix up religion with contract law. Religion is different, contract law is different. You can't mix these two things together. Because contract law is objective test, religion is subjective test. Contract law is objective test, religion is a subjective test. So you cannot bring subjectivity into objectivity. Do you understand this? Anybody have any question? Okay. I think no issues. Now I'll go on and look at Wilson against Bernard. That's the last case for domestic category. After this, we'll be into commercial category. Right? That's the last case under domestic category. Wilson against Bernard, 2007. So again, the importance of citation. EWCA means England and Wales Court of Appeals. 110 means 1170th case of 2007. That's what it means. May Lord Justice stated this. On 20th January 2005, this is what happened. There's these three ladies, right? But this Tanya Bernard, right? Tanya Bernard and two of her friends. So what Tanya Bernard was actually telling her friends, she went and, played bingo game. So she told her friends, if I win this game, I will share the prize among all of you. So, sometimes we will say this to our friends, bro, if I get like 10 million USD in my life, I will give you 500,000, bro. Things like that. But you say this out of a jest. But sometimes, I don't know whether it's a fortunate situation or unfortunate situation. When you want the prize, would you have the willingness to share with your friends? So this is what Tanya did, exactly like what I said. Tanya was there that night playing bingo with two friends with whom she worked. And then she went and told the girls that if I win, I would share any winnings equally. And she won not only the local prize, 153 pounds, but she also won the national bingo prize, 101,211 pounds, which is quite a very big money. So it went to court because she refused to give the money to her friends. She refused to divide the money between her friends. By right, now the friends are asking 33,736 pounds because they said that Tanya Bernard was the one who actually promised this money to us. This is the reason. Sometimes when you get too excited in your life, right, you want to go on and, promise that I will give you that, they'll give you this. But it turned out to be like this. All okay? Okay. So, go on and look at what the court stated. Right? So, the answer here depends on ITCLR. Is there an ITCLR between the three friends? Before you go, you already know what is the answer for this. Before you look at the judgment, you already know what was the answer. What is the category? Is it domestic? No. Social. Because friends means will come under social category. What is the presumption? No ITCLR. Is that rebutted? No. I don't see any rebuttal factor. Right? So the court stated she don't have to shed. See, the issue in this case was in the end a narrow one. That is whether there had or had not been a sufficiently certain binding agreement at the girl's place of work or an earlier occasion. There were intrinsic problems with an agreement such as this, both of definition and of the question whether a necessarily casual conversation could be elevated into an agreement binding and enforceable in law. The court stated no. Because a casual conversation, I said that, hey, bro, if I win, I'll get money, I'll make you rich. You are, my blood, things like that. It will not create ITCLR. And on the facts, there was no ITCLR. We are done with domestic or social category. Completely done. Anybody have any issues? Any issues? Okay. If no issues, then the next category is social. Sorry, commercial. See? Commercial category. That's the next category. Okay. Can you go to commercial agreements? You see commercial agreements? So for commercial agreements, I told you under commercial agreements, there's always an ITCLR, right? There's always a presumption of ITCLR. But I also told you that it can be rebutted, right? Even for commercial agreements, the presumption of ITCLR can be rebutted. So we are looking at some special situation where in those situations, either ITCLR has been rebutted or probably not rebutted. Essentially, we are looking at the rebuttal factor. See, in commercial agreements, rebutting ITCLR is very difficult because even if your boss is your father, but you are suing him in the capacity of boss, not as your father. Right? So, you go to commercial agreements, for the 3.1. The express declaration by the parties that the agreement is not binding in law. Well, if you look at this, the express declaration by the parties that the agreement is not binding in law, it means all commercial agreements automatically have ITCLR. But if you do not want an ITCLR, if you want to negate it, if you do not want this contract to be enforced in any court of law, then you can put a term there that this particular agreement in no way creating any ITCLR. That's what happened in the case of Rose and Frank Crompton Bros. Can you see Rose and Frank Crompton Bros? In Rose and Frank Crompton Bros, the facts are not important to us, but there was an honorable pledge clause. Honorable pledge clause. So what is this honorable pledge clause? Let me see what was written there. This arrangement is not entered into, nor this memorandum written as a formal or legal agreement, and shall not be subject to the legal jurisdiction in the law courts either in the United States or England, but it is only a definite expression and record of the purpose and intention of the parties concerned, to which they honorably pledge themselves. Meaning to say, honorable pledge clause is actually a clause that negating ITCLR. Look at what they say. This arrangement is not entered, nor this memorandum is written as a formal or legal agreement. So they say it's not a legal agreement. They say it's not a formal agreement. And shall not be subject to legal jurisdiction in the law of courts, whether in United States or England. Meaning to say, you don't have an ITCLR. If you don't have an ITCLR, if you have written it down in your contract, the court will enforce it. right? If there's no ITCLR, meaning there's no ITCLR. Do you get this? Okay. That is actually for uh, honorable pledge clause. Remember, if you do not want to create ITCLR, you just write in the agreement there's no ITCLR. Okay? Okay, now we go to the next part. Gratuitous promises or ex gratia. Do you know what is ex gratia means? You know what is ex gratia means? Ex gratia means ex gratia. The word ex gratia means morally obligatory. I will write this here. Morally obligatory. It's not legally obligatory, it's morally obligatory. Meaning, it's like a moral payment. So if I write the word, this is just a moral payment, it's not a legal payment in my agreement, do you think it will rebut the presumption? Because the presumption is in a commercial agreement, there's always ITCL. Okay, this was explained in the case of Edward against Skyways for gratuitous promises. Edward, he was a pilot of Skyways. So Skyways called him and said that, sorry, we are suffering a bit. So we had to sack you, right? But there's this a different scheme where there's an employee occupational scheme where the employer has to pay the employee under that scheme if they actually sack the employee. So Skyways, which is an airline company, called Edward and said that if we sack you, we have to pay for the occupational pension scheme. But if you resign on your own, we will give you a lump sum, right? So we also won't have to pay and you also get some money. So Edward thought that this was a good deal. So Edward thought that, okay, let me just go and resign. So he went and resigned. And in that contract, before he resigned, it was stated that we will give you, if you resign on your own, we will give you an ex gratia payment. The problem is, Edward did not know what is ex gratia and he went and signed. But then later, they don't want to give him the ex gratia payment because the lawyers for Skyways telling the word ex gratia shows that they have no intention to create legal relationship because ex gratia means morally obligatory payment. It is not legally obligatory payment. Went to court. The court was like, we are not idiots, right? Wait, okay. The court was like, we are not idiots. We know that this is a fully commercial agreement. See, remember what I said. Simple. Remember what I said. Category is domestic, means no ITCLR. Category is commercial, means there's always ITCLR. Plus it can be rebutted. So what they are trying to say, the word ex gratia as a rebuttal factor. But the court stated the presumption here is so strong. The presumption here is so strong that a mere word ex gratia will not negate the ITCLR. There is still ITCLR. Meghaw J stated this. The defendant's argument that the use of the word ex gratia showed that the parties do not intend legal relations failed. Why? This was a commercial transaction and therefore there is a presumption of ITCLR because this was a commercial transaction. In a commercial transaction, remember what I said? It's very difficult to negate ITCLR. It's very, very difficult in a commercial situation. The presumption is not rebutted. And therefore, Skyways wanted to pay Mr. Edward. I mean, Skyway had to pay Mr. Edward. right? Not only the money that was promised to him, but including some fine damages and all. He could have actually just paid the fee, right? I mean the compensation. Any issues? So we have looked at two things, right? We have looked at Edward against Skyways, and we have also looked at honorable pledge clauses, right? And next up is letters of comfort. Okay, I'm going to give you a short break now. After the break, we will continue with this. Okay, I'm back. So before the break again, we have looked at gratuitous promises. We have also looked at express declaration by the parties that the agreement is not binding in law. And apparently in heading 3.1, the express declaration by the parties that the agreement is not binding in law, the court has very clearly stated that if you do not want ITCLR, then there's no ITCLR. But if you go down and look at gratuitous promises for ex gratia payment, where the court stated even if you put the word ex gratia, that is still ITCLR. The word ex gratia, what is ex gratia means? Morally obligatory payment. The word ex gratia indicates or will not indicate, right? It will not indicate the, how do I say it? The words ITCLR, sorry, the word ex gratia will not negate ITCLR. It will not indicate anything other than the normal commercial agreement. You can't negate ITCLR by including the word ex gratia. Right? So I explained to you the facts of adverts against Skyways just now. Then we go to letters of comfort. Letters of comfort is very important. It also does comes out in exam frequently as well. In letters of comfort, we are looking at, you know what is a letters of comfort means? Okay, I'll explain to you via the case law, then you will understand this. Can you see this case of Cleanwood Benson against Malaysia Mining Corporation, MMC. Cleanwood Benson Limited against Malaysia Mining Corporation, BHT. So I'll tell you what happened on the facts of the case. See here. So this is the bank. This is parent company. And this is subsidiary company. Right? The subsidiary company. So the subsidiary company is MMC Metal, Malaysia Mining Corporation. So Malaysia Mining Corporation wanted to apply for a bank loan. But then the bank was looking at the accounts and others, and they were not really that confident on the bank. Sorry, on the subsidiary company, MMC Methods. So what the bank did, the bank asked MMC to get a letter from the parent company. Get a letter and pass the letter to us. We may consider giving you the loan. So MMC Method went and told this to the parent company. Parent company said that okay, we'll give you the reference letter. So this is what happened. In that letter of reference, it was stated, it is our policy to ensure, right? It is our policy to ensure that the business of MMC Metals is at all times in a position to meet its liabilities to you. This was what was indicated in the letter. So a policy to ensure that the business of MMC Metals is at all times in a position to meet its liabilities to you. So as stated. See, they did not say, if MMC Metal never pay, we will pay. They did not say so. They just said that's our policy to ensure that business of MMC Metals is at all time in a position to meet its liabilities to you. That's all. Right? That's all. Do you think this is a guarantor letter? And I'm merely indicating what is the policy of my company. Do you think by any chance this will be a guarantor letter? I don't think so. I'm just telling what is my policy. I did not say that if they never pay, I'll pay. So problem is MMC Metals defaulted in loan. This is the subsidiary company, MMC Metals, defaulted in loan. They can't pay the loan. Can't pay. So bank went and asked the parent company, can you pay? Parent company say, we never said if they never pay, we'll pay what? We just said that what is our policy? Look at this again. What we said? What we said was, it's our policy to ensure that business of MMC methods at all time in a position meet its liabilities to you. We just gave a comfort letter. See, we call this a letter of comfort. What letter of comfort does? Letter of comfort will make you comfortable. That's all. Letter of comfort will make you comfortable. So, it went to court. In High Court, Hurst J. In High Court, Hurst J stated the transaction is commercial because what is actually the category? Commercial. Presumption, there's always ITCLR. And he decided that the letter of comfort will not rebut the ITCLR. There is ITCLR. Went to Court of Appeal. Court of Appeal. You know what is this High Court, Court of Appeal things, right? Right. I see. Wait, I'll tell you. I know because some of you may not have learned this. So some of you may not be taking legal system and method. Even if you are taking legal system and method, it's only starting much later in October only, right? So, see, civil, this is civil, this is criminal. So the lowest court for civil cases, all civil cases, will go to county court. This is the lowest court. From county court, it will go to high court. From high court, it will go to court of appeal. From court of appeal, it will go to Supreme Court. Sometimes in books, you can see the word House of Lords. House of Lords. It is actually the old name of Supreme. Currently, it is known as Supreme Court. Once upon a time, it was known as House of Lords. Then, under criminal cases, all the cases will go to Magistrate Court first. From Magistrate Court, it will go to Crown Court. From Crown Court, it will go to Court of Appeal. From Court of Appeal, it will go to Supreme Court. This is how it works. Right? County Court, all the way to Supreme Court, all the way to Supreme Court. Right? So, that's the division. Okay. So, this is what Court of Appeal said. The Court of Appeal disagreed with the findings of Hurst J at first instance. They thought whether there's an ITCLR or not, or whether it can presumption is there's always ITCLR. Whether can we rebut ITCLR or not, it depends on the wordings of the letter. See, they thought the question in turn turned to the wordings of the letter of comfort instead. Accordingly, if you see, I am just stating what is my policy. It is our policy to ensure that the business of MMC Metals is at all times in a position to meet its liabilities to you. Merely stating what is my policy will not create ITCLR. I'm just stating what is my policy. Look at what Ralph Gibson, Lord Justice, stated in Court of Appeal. The concept of comfort letter was, as acknowledged, not shown to have acquired any particular meaning at the time of the negotiation, in this case with reference to the limits of any legal liability to be assumed under its term by a parent company. Right? Because the wording is just merely stating the policy of the company. All okay? So whenever you give a reference letter, you must look at the wording. You shouldn't write, if they never pay, I'll pay. That's actually a little bit problematic. If you say that if they never pay, I'll pay, then you got to pay. But if you say that our, MMC Metal is actually a good company, we are sure that they will pay on time, that's enough. that means you can't be sued. Anybody have any issues? Anybody want to ask any questions? Okay. Now we'll go to the next one, subject matter having little intrinsic value. And we have this case called Esso Petroleum against Custom and Excise Commissioners. So this is during 1970 World Cup season. At that time, Esso Petroleum was actually giving World Cup coin like memorabilia to people who has actually like a souvenir, right? For people who has actually bought certain liters, certain gallons of petrol from them. So the issue here was it was marketed big, right? It was marketed big, and Esso was telling, try to collect all the coins because there are different coins. So if you are a collector, please collect all the coins. And the marketing goes this way: one coin given with every 4 gallons of petrol. The thing is, do you think the coins needs to be subject to purchase tax? Because Custom and Excise Commissioners are telling these coins are actually for general sale. But then Esso is telling, no, we are not selling the coins. We are not selling the coins. These coins are actually free of charge. Coins are actually free of charge. If you put petrol for every 4 gallons, we'll give you 1 coin. So why we have to pay purchase tax for this? Because purchase tax is only applicable when there's a profit, when there's a sale. There's no sale here. There's no profit here. So why we have to pay purchase tax? Well, it went to House of Lords. And it's this what House of Lords stated. House of Lords judgment heavily divided here. Right? The issue here was whether it was a free gift or is there like a sale here? Right? That's actually a question here. So it went to court, and this is how they have decided. Lord Justice Viscount Dilhorn and Lord Russell, they stated that the coin had very little intrinsic value. Thought there was no ITCLR. Why they said there is no ITCLR? Because they said the coin is so small in value. That's why there's no ITCLR. But you cannot actually say there's no ITCLR because the coin is very small in value. Because the law will not look at the value as such. As long as it has some value, that's enough. Right? The coin need not to have a very big value. Then Lord Wilberforce and Lord Simon, they both of them stated, considered that there was such an intention. That means they are trying to say there was an ITCLR because the purpose, the whole was to attract customers. The arrangement was part of business relationship. So they are telling, which I think makes sense. They are telling that the whole purpose of the scheme is to actually attract more customers. So does it increases your sale? Yes. Whatever increases your sale, would it give you profit? Yes. Whatever gives you profit is subject to tax. Makes sense, right? Then the last, Lord Fraser of Tallybelton said, the determining factor cannot be whether parties would actually sue to enforce the contract. Right? The determining factor will not be whether you will sue to enforce the contract or not. Right? Why we are talking about suing? Because intention to create legal relationship means intention to sue. So there was a question, do you think customers can sue you if the coin is defective for any other reason? But Lord Fraser of Tallybelton said that's not the determining factor to decide ITCLR. So what was the judgment? The judgment was there is ITCLR. There was ITCLR, there is ITCLR, even if it is given for free of charge, because it's not truly free of charge, because you want to market it. Do you understand? Anybody have any question? All okay? So that is subject matter having little intrinsic value. Remember, we don't care what is the value. As long as it has some value, that's enough. Okay. Now we'll go to subject to contract agreements. And this is subject to contracts agreement. Subject to contracts agreement means it's like this. It this is a contract, and then there's a contract. So in this contract, they would say, we will sign a contract on the 12th. And this is the contract signed on the 12th. So that's what subject to contract agreement means. This is a contract to say there will be a contract on the 12th. So the issue here is, would this contract create ITCLR or not? Or only after you sign the real contract on the 12th, that is a real contract. Contract to have a contract is a contract or not? Contract to have a contract is a contract or not? Or contract to have a contract, which is this one, have ITCLR on it? That is the question. Right? Okay, so if you see the case of Blue against Ashley. Can you see Blue against Ashley? So Mr. Ashley is actually a business consultant. Sorry, Mr. Ashley is actually the owner of the company. He was actually approached by a business consultant, Mr. Jeffrey Blue. So this was actually the problem. Mr. Blue said Mr. Ashley appointed him. And Mr. Ashley's company is Sports Direct. Sports Direct is actually a very famous sports-related product manufacturers or retailers. So Mr. Jeffrey Blue was actually appointed to give some business consultancy for Sports Direct Group, and he was appointed by Mr. Ashley. So according to Mr. Jeffrey Blue, he said that there was actually a meeting in a pub, right, where Mr. Ashley was there, and also there are some other employees of Sports Direct. And in that meeting, Mr. Ashley promised to pay Mr. Blue. Mr. Blue is actually the business consultant. So he promised Mr. Ashley, who's the owner of the company, promised Mr. Jeffrey Blue, who's the business consultant, 15 million bonus if Mr. Blue can make the share price of Sports Direct Group to go up for £8 per share. If it goes up for £8 per share, I will give you 15 million bonus. But this was stated in a very informal meeting. Very informal meeting. So, Mr. Blue is telling, although it is informal meeting, there was an agreement. And of course, we are in a professional commercial relationship. And I have also made the share price to go up to £8. After that, I went and asked Mr. Ashley. He refused to give me the money. He is not giving me 15 million pounds. So it went to court. This is subject to contract agreements. Yes, I've said you something, right? But what I said, if the share goes up to 8 million pounds, there will be a contract to give 15 million pounds. Sorry, if the shares goes up to £8 per share, there's a contract to give 15 million pounds. So the contract is not created yet. I've said this. Now But if the shares goes up to 8 pounds, there will be a contract. I'll give you 15 million pounds. And at the same time, this was stated in a very informal setting, very informal meeting. So this is what the court stated. Mr. Justice Leggett dismissed Mr. Blue's claim on the grounds that the parties had not intended that Mr. Ashley would be legally bound by his extravagant promise to Mr. Blue. The main being that an evening of drinking in the pub was an unlikely setting for a formal contract negotiation. It was an informal setting. That's what the court is telling. Further, it was not actually within Mr. Blue's power to achieve the aim of increasing share above 8 pounds. Because whether the share increase or not, it's actually the company's performance. Am I right or not? So the court stated it was no more than a banter. That means a casual conversation. So there is no ITCLR. You understand this? So anything that was said or done before a real contract took place has no ITCLR. Anybody have any problem? Anybody have any issues? Okay, the last thing is unresolved for uncertain terms. After this, we are done with ITCLR completely. Unresolved for uncertain terms. If there are unresolved for uncertain terms, there's no ITCLR. You know, unresolved uncertain terms is where nobody knows what they are talking about, right? Just nobody knows what they are talking about. I also don't know what I'm talking about. You also don't know what you are talking about, right? Like in this case, Carl Michael Wallis against Leo Ronald, UK, 2003, right? Can you see these facts here? This person, Carl Michael Wallis, right? Carl Michael Wallis is actually an inventor, and he invented double-sided, multi-layered circuit boards. Circuit boards. So he's it's not a manufacturer, he's like an inventor. Then this person who's the defendant, Leo Ronald, he supplied products to businesses which manufactured printed circuit boards. Right? He's the person who supplied products for people who manufactures printed circuit boards. So he was very much interested in W's circuit board. So this what was exactly happened. According to Carl Michael Wallis, there was an oral agreement. There was an oral agreement with Leo Ronald, who's the defendant, and the agreement was for the development and exploitation of the patented process. That means we will develop this process together. We will also exploit. Exploit means we will sell it. Development and exploitation means we will sell it. So it was supposed to be done together with Leo Ronald. Anybody have any issues up to here? So remember, W is the inventor. So W said he had a meeting, right, with Leo Ronald. And I mean, Leo Ronald means Leo Ronald's employee, some senior employees like that. And then in that meeting, it was stated that they are promising to give a lump sum money for the patent. They will also give you some royalties, some annual payment, because they are going to manufacture, right, the circuit boards that you have actually invented. And then Carl Michael Wallis also stated he has actually accepted all the offers given by them, and there was actually a contract. But in the contract, it was stated we will do some further testing in order to find out whether how much we can sell this and all of this. But technically, prima facie, there is a contract. The problem here is right now they do not want to manufacture it because they found out that there is no prospect of sale. But W is claiming that no, there is a prospect of, there was an agreement, so you have to accept it. So it went to court. And you see what the court stated. Hell, On the evidence, the judge was fully entitled to find that there was no oral binding agreement between the parties. He was entitled to conclude that L lacked an intention to create a legal relation until the necessary technical tests had been carried out and prospect of long-term exploitation investigated. There were too many matters left undecided, and the judge was fully entitled to therefore dismiss the claim, appeal dismiss. Because the court stated, it was very clearly stated by Leonard that until we do further testing, there's no contract. Number two, in an informal agreement that both of you had, orally binding contract, there's, it wasn't really, like a contract. It was, all the pertinent details was missing. Right? So, when the term is unclear, we cannot actually go on and consider that as a contract. Because for it to amount to a contract, tomorrow we'll study this. For it to amount to a contract, all the terms must be clear and certain. So the court stated there is no contract here because it wasn't really certain. Plus, they have also very clearly stated this is also like subject to contract. Just now I said contract to have a contract. There's an informal contract, but we said that we will do some technical testing and we'll find out whether there's a good prospect for sale or not. After technical testing, we realized that there's no good prospect for sale, so we have rejected it. And therefore, there's no ITCLR. Any issues? All okay with this? Okay. So if the terms are certain, then there's a contract. If the terms are not certain, then there's no contract. We'll go on and look at that much later in detail when we are looking at this tomorrow for offer and acceptance. And if you go down, right, you can also see as you go, right, there are certain sort of like an activity. Even from the beginning, you must have been looking at this activity 1.1, 1.2, 1.3. These activities to test your understanding. You don't have to like fill up and give it to me, but you have to know this, right? Generally, you have to know this. Like, if let's say you never studied this case yet, we haven't studied this case yet, then you can leave it blank, right? But whatever you can answer. Like you can see the phrase binding in honor only in contract. What does that means? Binding in honor only means it has no legal effect, confirms that the parties did not intend legal relation, or proves that the parties did not intend legal relation. Binding in honor only in court means you must be able to think, right? It confirms that the answer is yes. The parties did not intend legal relations, right? And if you go to number 3, not subject to jurisdiction of the law of courts means it has no legal effect. So as you go on, you will realize that when you do these activities, it's better for you because you will know what we are talking about. It will also like a self-evaluation for you. Plus, if you go down, there is actually a relationship between, there's like sort of an essay in regards to relationship between legal relationship and consideration, right? Relationship between ITCLR and consideration. Well, the relationship between ITCLR and consideration, we cannot study this now because we have not learned consideration yet. So we have to wait until we learn consideration. Only then we can go on and look at this. Right now, we can't look at this because we have never learned consideration yet. Right? Consideration is actually a 3rd chapter only. Right? So we can't look at this right now. And then if you go down, right? If you go down, you can see under reason development. You see reason development. There are certain cases, certain new cases. Like you can see the case of Wells against Divani, 2019. Right? Can you see 2019 Wells against Divani? Supreme Court noted the strong inference that there was an ITCLR in relation in a standard commercial transaction between an estate agent and an owner who wants to sell property via the estate agent. This is what I told you. In commercial agreement, there's always a strong presumption of ITCLR, and it is very difficult to negate it. Very difficult, right? Because you have looked at this even in Edward against Skybase. The word ex gratia, the court said it means nothing. Then the case of RTS flexible system against Molkere, Alois, Muller, GmbH and Co. KG, UK production 2010, where Supreme Court held that where the parties had not signed or executed the draft contract in accordance with its terms, but had completed the work specified and partly paid for it, the parties intended to create legal relations. This is also quite significant because although the contract is signed, but the work had been executed, part of the work. Apparently, if you have accepted that part of work, it means there's already an ITCLR. You cannot say because the contract is not signed, there's no ITCLR, and therefore I won't pay you. Right? Because while they were doing the work, you were quiet. Means you accepted the work. So these are all some new cases are there. Well, 2010, it's not really so new case. But there are some new cases here, like many of it I've taught you, like, New Testament Church of God against Stewart. We have looked at that just now. This is actually the case of Crass Nicholson, Londanium against Akaria Investment, 2010. The Court of Appeal held that there was a difference between court's task in determining the terms of a contract which both parties agreed had been made, and the court's task in determining whether or not contract had been made. You know what are they trying to say? Right? When both parties said that they agreed that certain terms are there, and the court's task in determining whether or not a contract had been made. The first one is contract is there, but whether the terms are in place or not. To decide that is different than to decide whether there's a contract or not. Because in second possibility, we are deciding whether is there a contract or not. Second possibility, first possibility, we are deciding whether there are terms or not in the contract. In the second possibility, we are deciding whether there's a contract or not. In the first possibility, there's already a contract. Do you understand this? So as you go down, you will see some cases. Remember, this book is quite, how do I say this? Quite comprehensive. But you don't have to know all the cases. Right? It's very, very comprehensive. You don't have to know all the cases. Whatever cases that I've taught you in class is considered to be very, very important. If I've never taught you the class, it means the case. Sorry. If I've never taught you the case, it means not to say it's not important, but it is less important. Right? You may or may not remember that case. Okay, anybody have any issues that you would like me to address? We are done, right, with the first chapter called Intention to Create Legal Relationship. So tomorrow I will cover with you offer and acceptance. We may or may not able to finish this, depending on whether you understand this or whether you have any question. We will see, right, offer and acceptance tomorrow. So if no question, then I would like to end the class for today here. Anybody have any question? Okay, if no question, then I'll see you tomorrow at 9:30 a.m. Thank you very much. Bye.